Hello and welcome again to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the MPZ Law Group, and with me today is Ludka Zimocek, my law partner. Ludka and I are going to talk a little bit about the new rule that just recently was promulgated, which has to do with some changes that were made in the E3 classification with regard to the H-1B1 classification, and also some interesting changes that were made in the outstanding researcher classification. Just by way of sort of a lay of the land, and historically, this rule had been pending for a very long time. It's a very frustrating thing for us because we were trying for a long time. We would, we were hoping that clients would be able to get continued work authorization when they filed their extensions, but they didn't have it in the E3 H-1B1 classification.
Which is very interesting, since H-1B would have an extension.
That's exactly
and
right.
And H-1B1 would not. It was very difficult for clients to understand. But
right.
Maybe you want to explain how
well, yeah, so why don't
work.
Yeah, why don't we explain? Let's explain it this way: is that when you have an H-1B and you file an extension of an H-1B, the rules on the filing of the extension give you an automatic additional 240 days of work authorization. And so really what you're allowed to do is to continue working
while your petition is pending.
Which makes a lot of sense.
Yes.
It makes a lot of sense. And so, but interestingly, the E3, which is the treaty between the United States and Australia that did not have it, and the H-1B1, which is the Singapore Free Trade, the Singapore-Chile Free Trade Agreement, that didn't have it either. So the individuals really had to file way in advance.
Or they had to leave.
Or they had to leave the country and go pick up.
Which was a big burden on employers as well as employees.
Exactly. The only ones it seems that would be good for is the hospitality trade and the airlines, because they were taking the people home and then they would have to stay in the hotels and wait for their visa stamps.
Because just imagine a scenario that the petition would have been filed 6 months in advance, but sometimes, especially these days, USCIS has exactly significant delays. If the petition is still pending, the person would not be allowed to work.
Exactly. So this was a very welcome fix. The rule came down, I believe, at in the middle of January of 2016, thereabouts. So we were very happy to see it. There was also another provision in this rule, which of course is tremendously helpful to certainly to our practice, because we handle a lot of scientists, researchers, and doctors, and that has to do with additional evidence, or what's called comparable evidence, for the outstanding researcher.
Which is EB1 category.
Exactly. It's an EB1-2 or EB1B classification. Outstanding researchers are individuals who are outstanding in their field, working for an employer who is sponsoring them, where they have 3 or more researchers on the staff. And so what this does is it gives us an opportunity not just to go by the additional criteria, because there are criteria that are set up in the regulations, right? Things like awards and publications,
original contribution, memberships,
exactly,
peer
review, and so these are all things that obviously are listed. But for some of our researchers, maybe they have something different. Maybe they have something else.
For example, there are specific fields, math, for example, or physics, where the researchers do not publish as much. They would be internationally recognized, but they wouldn't have enough evidence to prove outstanding researcher petition. So this opens up this classification for professors and researchers.
Exactly. So this, exactly. So this opens the door to liberalizing the types of evidence that can be brought in. Of course, when we sit with our clients, we always ask them to provide us with a full-blown resume about every single thing that they've done in the field, with the hopes that we can marshal those particular items that they've listed into those various classifications. But sometimes we're left with some other ones where we can't really fit them in that easy. And so what this does is it gives us a catch-all to be able to make an additional argument on behalf of our clients to sort of help them to get approved petitions.
Yeah, it's a great benefit to all professors, researchers
scientists
that do not fit into those criteria.
Exactly. With that, I want to thank you very much for being with us today. It's a pleasure to be able to bring this cutting-edge information to all of our viewers. If you have any particular questions or issues that you would like us to discuss on Immigration News and Views, please feel free to send them to us at the email on your screen, or please feel free to give us a call. We'll be more than happy to assist you. Thanks so much for being with us today. Bye for now.